Hello, I'm Eric Masters, Director of the Douglas A. Fraser Center for Workplace Issues at Wayne State University. It is my pleasure to present our video on how labor arbitration works, the case of the contaminated kitchen. This video is based on a real case, and most of the actors are professionals in the area of employment and labor relations. Names and identifying details have been changed to protect the privacy of individuals. Mr. George Rommel, a widely known and respected arbitrator who conducted the actual hearing and decided this case, will offer some helpful advice that union and management representatives need to know in order to make a persuasive case to an arbitrator. He will also give tips on how to avoid some common mistakes. We will provide you with information on how to prepare for an arbitration and how to conduct an arbitration. Advocates of arbitration on the employer and employee side will learn how to coach their witnesses and how to present opening and closing statements. Labor arbitration is a commonly used method of dispute resolution to handle disagreements over the interpretation and administration of collective bargaining agreements. In this video, we have attempted to give you an informative, moving picture of how labor arbitration works from beginning to end, starting with a reenactment of the workplace incident that led to the filing of an employee grievance. How labor arbitration works. The case of the contaminated kitchen is the product of the Fraser Center's project People at Work, a digital learning network.
Dang, I just cleaned this area. Sorry.
The incident that you have just watched is based on an actual case that occurred in a hospital kitchen. The hospital fired this employee, and his union has brought the case to arbitration in an attempt to get his job back. What was the process that brought us here? How will the arbitration process work? What are the key factors that the arbitrator will use to decide the case? If we know what those key factors are, will that help us to prepare for a successful outcome? Are there some key steps we should be taking in order to prepare well? What you are about to see is an abbreviated introduction by the arbitrator and the opening statements of the parties. Let's watch.
Good morning, everyone. I understand we have a discharge case today, and since it is a discharge case, the burden is on the employer. And therefore, Ms. Summers, I ask that you give your opening statement first.
Thank you, Mr. Arbitrator. The hospital terminated this employee, Gary Walker, for violating the health and safety provisions of our collective bargaining agreement. The grievant did this by deliberately throwing garbage that he had swept up from the floor onto a food preparation table in our kitchen in the hospital, posing a very real contamination hazard to both patients and fellow employees. This is not the first time that this employee has allowed his temper to get the better of him, and the hospital will show that our decision to terminate this employee was justified and for a good cause.
Thank you. Mr. Dixon, representing the union, I invite you to make an opening statement.
Thank you, Mr. Arbitrator. We brought this case to arbitration because we believe the employer has not terminated the employee for good cause. This employee is a long-term employee, has a good work record, and has performed satisfactorily in the past for the hospital. We don't think the employer has proven just cause, and we ask that the grievant be returned to work and made whole for his time off.
Thank you. Ms. Summers, would you call your first witness?
Yes, the hospital will call its first witness, Ms. Jill Blanchard, the head chef.
Ms. Blanchard, will you raise your right hand, please? Do you swear or affirm that you'll tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
You may examine.
Thank you. Ms. Blanchard, would you please state your full name and your title?
My name is Jill Blanchard, and I'm head chef at the hospital
And how long have you worked at the hospital?
for 8 years.
And before that, where did you work?
I worked at another hospital as a head chef for about 4 years.
And would you mind stating your training and credentials for the record?
Yes, I received both my bachelor and my master's degree in culinary arts from the State University.
Thank you. And how long have you known the grievant?
About 7 years. When I first started, I was warned by HR about his attitude.
Objection, Mr. Arbitrator. The witness is repeating hearsay.
I agree that's hearsay, and so I'm instructing you to only testify to what you saw or what you heard.
We understand, Mr. Arbitrator. What was the grievance position at the hospital, and what did that position entail?
He was a custodian, so he was responsible for cleaning the kitchen and sweeping the floors.
And would you tell the arbitrator what you personally observed regarding Gary's bad temper or attitude?
Yes, from what I observed, he just wasn't smiling. He wouldn't say hi to people. He wasn't friendly to coworkers. And frankly, I think he freaked out fellow employees and the patients.
Calm down here. We'll get a chance to tell our story.
All right, so what happened on the day in question?
Well, on the day in question, I walked into the kitchen and I saw him dump the garbage from his dustbin on the prep table. Right on the prep table. And I don't think he thought that anyone else was in the room. He was slow to fix the problem and clean up the area. I think he thought he was alone in the room.
And then what happened after that?
Well, when he cleaned up the area and he disinfected the table, and when he saw me, he turned around and said he was sorry, and he left.
And what did you do?
At that point, I went to the security office to make sure that it was on video. We watched the videos. And then I came down to your office to get recommendations for next steps and for discipline.
All right, thank you, Ms. Blanchard. That's all I have for now.
You may cross-examine.
Thank you, Mr. Arbitrator. Ms. Blanchard, you say that you've worked at this place for 8 years?
Yes.
And would you mind describing your duties and your position?
My duties include, basically, I'm in charge of all operations in the kitchen. So I direct the staff and make sure that the health and safety codes are upheld. I order food and also make sure that the food meets customer satisfaction.
With such a broad range of responsibilities, have you ever observed the grievant doing his work?
Yes, I see him every day, at least once a day.
And you stated that you've never seen him lose his temper in doing his work?
No, but I know that his work record includes some previous write-ups from about a year ago that I was not involved in for poor work performance, and a couple years before that, he received a 3-day suspension.
I see, but as far as you know, there's nothing in his work record that would indicate he's ever been disciplined for having a short temper.
No, but I just want to say that clearly these 3 incidences within this short time span indicate that he does not appreciate this job. And frankly, I'd like to get someone else in here that would appreciate the job and come to work and be happy here.
Thank you, Ms. Blanchard. No further questions at this time.
Thank you. Any cross-examination? Redirect, I'm sorry.
No.
Thank you very much.
As the moving party in this termination case, the employer, the hospital, has completed the presentation of its case. What do you think their major points are? What do you think they are trying to accomplish? What did they do well? Are there some points that they could have made better?
Is the union ready to present their case?
Yes, we are, Mr. Arbitrator.
Call your witness, please.
The union calls its only witness, the grievant, Mr. Gary Walker.
Ms. Walker, would you raise your right hand, please? Do you swear or affirm that you'll tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
Thank you very much.
Gary, will you please tell the arbitrator what you do at the hospital?
Yes, I'm a custodian at the hospital. My primary responsibility is making sure that the conference room, dining area, dining hall, and kitchen is clean and kept in order.
And how long have you been doing this work?
I've been at the hospital for over 15 years, and I've been assigned to the dining area and kitchen for almost 12 years.
And what do you like about the work you do?
Well, I like keeping things very clean, spick and span. Just in case a group of visitors or inspectors come through, they are impressed with my work.
Visitors come through often?
Yes, ever since we won Magic Hospital Award, they come by about once a month.
Is there anything else you like about the work that you do?
Yes, I like saying hello to other employees every day. And sometimes getting to help patients and other people who need help with wheelchairs, walkers. Make me feel good to help.
Could you please tell the arbitrator what happened on the day in question?
Sure. Since lunch was almost over and almost everyone's been served, I headed back to the main kitchen there to prepare for the final cleanup. I already done the floors and table earlier this morning since I was told that the hospital was expecting visitors for the accreditation team, so I wanted to make sure everything was perfect. Just as I began to clean the floor again, I saw the chef take out the last large lunch special, pot roast, meat, and vegetables out of the oven. The meat was already sent to the front serving line. All was left over was juice, onions, and some small leftover vegetables. The chef was so eager in removing the pan, she spilled it all over the floor. Went underneath the serving table on both sides. That meant I had to clean that area up all over again.
Did you hear the manager testify about putting sweepings from the floor onto the prep table?
Yes, I did.
So you don't deny this?
No, I do not.
Can you tell the arbitrator why you did what you did?
Certainly. First of all, I'd like to apologize for losing my temper. Looking back, I know what I did was wrong, and I'm sorry for my actions. For several months now, I felt that the chef and even a couple of her assistants was going out their way to cause me problems.
In what way?
On 3 or 4 occasions, after especially doing a careful job in certain areas of the kitchen prior to an inspection, the chef and her staff messed things up. Instead of taking the same pride of areas of the kitchen that looks better than it did in years, they purposely take pleasure in messing things up. I even noticed that the chef laughing and grinning with one of her assistants.
Do you have any reason to believe that the chef may have been engaging this behavior on purpose?
Yes, she told a couple of her line servers that she had a 24-year-old nephew who was out of work and just needed to get her foot in the door as a janitor, dining room janitor, my job. I think she deliberately caused me problems to get me fired.
I see. Just a couple more questions, Gary. Do you have any other discipline-related incidents on your record?
Yes, there was 2. About 2.5 years ago, I got a 3-day suspension for poor work performance. I got a letter of recommend about 1.5 years ago for work performance.
But isn't it true that your collective bargaining agreement provides that the employer cannot consider discipline that occurred more than 2 years ago?
It shouldn't be considered.
No further questions, Mr. Arbitrator.
Ms. Summers, cross-examination.
Yes, please, thank you. Gary, now you did state that you have a disciplinary that was given to you about 2.5 years ago?
Objection, Mr. Arbitrator. We've already established that the collective bargaining agreement contains a provision limiting the discipline that an employer can consider to the past 2 years. This question is irrelevant.
But Mr. Arbitrator, I was trying to establish that the grievant had a track record of poor work performance that goes back some time now. But I'll withdraw the question.
All right, thank you. Proceed, please.
So, Gary, how would you describe your everyday attitude? Are you happy at work?
Yes, I'm glad I have a job.
Do you have many friends at work? Do you like your colleagues?
I have a couple of employees from work. Sometimes we go out for beer, we'll go bowling. My friends have jobs like mine. People that wear ties and suit jackets, they do not acknowledge me. They don't make eye contact. They don't even say hello.
Do you make eye contact or do you say hello?
I guess I tried for a long time, but recently I just gave up. I was tired of being ignored or treated like I was not there.
No further questions, Mr. Arbitrator.
Thank you. Do you have any redirect?
No redirect, Mr. Arbitrator.
Thank you. Do you have any other witnesses?
No, we do not.
Does the employer have any rebuttal witnesses?
No, we do not.
All right. Do you intend to file a post-hearing brief, or do you wish to make closing statements?
Closing statements, Mr.
Closing
Arbitrator.
statement.
You agree? All right. I'll call upon the employer to make their closing statement.
Fine.
Both sides have now finished presenting their cases. As you have seen, presenting a case involves the calling of witnesses and the establishment of the facts as both sides see them through direct and cross-examination. Once the parties have rested, that is, their cases have been completely presented, it is time for them to prepare a closing statement. In a case like this, where discipline or discharge is involved, management bears the burden of proof. The decision that an arbitrator is going to make will often revolve around the application of a universally accepted 7-part test. The 7-part test is designed to determine whether or not the action taken by management was for just cause. Now, I'm going to explain to you what those 7 parts are. Number 1, did the employer make the employee aware that certain conduct by him or her could result in discipline? Number 2, was the discipline reasonably related to the orderly, efficient, and safe operation of the organization? Number 3, did management make an effort to determine if the employee actually violated the rule or order before handing out the discipline? Number 4, was the investigation conducted fairly and objectively? Number 5, did the investigation show that there is substantial evidence that the employee violated the rule, and did the employer therefore meet their burden of proof? Number 6, have the rules, standards, and discipline been consistently applied by the employer and without discrimination? And finally, number 7, was the degree of discipline appropriate, considering the seriousness of the offense and the record of the employee?
I'll call upon the employer to make their closing statement.
Fine. Well, Mr. Arbitrator, the actions that were taken by the employee in this case were reckless and put the entire hospital community, both patients, visitors, and staff, at risk. If anyone had become sick from this deliberate and vindictive behavior, the hospital would have been liable for significant financial damages. We would have been tied up in settling lawsuits for many years. We would have run the risk of losing our accreditation or even being shut down. And it would have taken years to simply restore our image in the minds of the public. The hospital therefore stands by its decision to terminate as a serious violation of the work rules, and really just failure of good judgment that we expect from our employees, we ask that you sustain his termination.
Mr. Dixon?
Yes, Mr. Arbitrator. Since this is a discipline case, management bears the burden of proof of demonstrating that their discharge was for good cause. In order to convince the arbitrator, the proof must meet a just cause standard. As you very well know, there's a universally accepted 7-part test that includes, among other things, that the discipline be appropriate. In other words, does the punishment fit the crime? This was the only discipline on the grievance record in the past 2 years. And the idea that the employer could use this incident as a basis for termination of a long-term employee does not meet the test. While the grievance action may not have been proper, no injury to anyone resulted, nor was there any harm done. I might also point out that the grievant recognizes what he did was wrong and delivered a sincere apology. The union therefore requests that the grievant, Mr. Gary Walker, be returned to his job and made whole. Thank you.
Thank you. Well, I want to thank both of you for a very fine presentation. I have 30 days from today to write my opinion and issue my award, and I will do so. Okay, the record is now closed. Thank you very much.
Thank you.
Notice that the parties have agreed not to submit post-hearing briefs. Therefore, the formal presentation at the hearing has been completed and the record will be closed. Had the parties decided to submit post-hearing briefs, they would have also have agreed to a deadline by which the briefs would be submitted. The record, so to speak, would be kept open until the receipt of those briefs, and then would be closed so that the arbitrator can begin his deliberations. After the parties have finished their submissions, the arbitrator will begin his review, the notes from the hearing, the exhibits that were submitted, and finally the post-hearing briefs or documents. The parties expect that his opinion will be clear, will be objective, and will be something that they can understand regardless of the outcome. Basically, the options that the arbitrator has are threefold. He can sustain management's decision, which means that the janitor will continue to be terminated. Number two, he can reverse management's decision and order the hospital to take the janitor back to work. And number three, he could fashion some form of a compromise remedy which would be a balance between the positions of labor and management. George, thank you so much for demonstrating the role of an arbitrator in the hearing. But I do have a few questions for you. My first question is, what are some of the most common mistakes that advocates make in an arbitration hearing?
Well, number one, they don't have a plan of how they're going to present their cases. Number two, they don't put themselves into the position of the arbitrator, of what they think the arbitrator may be thinking, and in order to psych out the arbitrator. Number three, they don't prepare their witnesses, including preparing the witness to answer questions on cross-examination. And without doing that, they're not doing their job.
Thank you. My second question is, what are the most important points for advocates about opening statements? Well,
the opening statements, number one, should never contain a statement that they can't prove. Okay. They got to be sure that they know what they can prove, because in the opening statement, they're telling the arbitrator what they're going to prove.
I see.
And number two, in the opening statement, they should emphasize the key point they're going to prove that will make their case. Like, for instance, the fact that they threw these vegetables on the table, contaminating the table, and we serve 1,000 patients a day.
Thank you. So is there a standard length for how long an opening statement should be?
No, depending on the case. If it's very complicated, it may be a little bit longer than normal. But I think in a normal case, such as this, the opening statements should be 5 to 10 minutes at the most.
Okay. Are there any situations in which the parties should not do an opening statement?
Well, there are 2 points of view on that. Obviously, the party that had the burden of proof, in this case the employer,
Right.
they have to do an opening statement because the arbitrator had no idea what the case is about. Now, in this case, the union should have made an opening statement because the employer's opening statement was devastating, or could be, and so the union has to bring the arbitrator back to realism. But if the union believed that the employer can't prove their case,
Right.
and the union doesn't want to tip their hand, there may be some cases where the union will reserve their opening statement until they present their case.
I understand. Okay. So we did see a couple of examples in the hearing of cross-examination. Do you have 2 or 3 tips for the parties about doing cross-examination?
Absolutely. Number 1 tip is to listen. In other words, you're cross-examining a witness to get a certain point, certain information. Now, you may have an idea you're going to ask 10 or 15 questions, but if the witness at the end of the second question you ask gives the answer you're looking for, stop. Don't ask the other 12 questions. So listen to what they're saying. Furthermore, keep your questions short. Number 3, never argue with the witness. And number 4, all you're doing is trying to get facts or trying to show inconsistencies.
Thank you. That's very helpful. Earlier on, you mentioned the importance of coaching the witness. What should the advocate's purpose be in coaching before the hearing?
Number 1, a witness should always be told to tell the truth.
Okay.
And an advocate should never encourage a witness to be untruthful. But there's ways in coaching a witness. For instance, as I pointed out, your own witness, be sure they understand what questions they might be asked on cross-examination and how to answer them. Or how do you describe a day? Now today in Michigan, it's almost 55 degrees. But normally it should be cold. Now, one witness might say, well, it's a pretty okay day. Another witness might say, it's an unusually nice day in Michigan for this time of the year. Both of them are telling the truth.
Right.
But if you're doing a good job coaching, the second answer would be the better answer from your standpoint.
I see. So we also had a situation in the hearing where both advocates chose to make a closing statement. Are there tips for what the parties should do in preparing and making those statements?
Well, in your closing statement, you should hit what I call the jugular vein of your argument. Now, from the hospital case, they're saying, we don't employ custodians in the kitchen to throw contaminants on a table in which we prepare food for sick patients. And that is what this is all about. This is a hospital, not a factory. And our patients are susceptible to disease, viruses, and this is what we try to avoid. Now, on the other hand, from the union standpoint, this is a 15-year employee, only 1 reprimand that can be considered. He apologized, he made a mistake, but you don't discharge him for him. He can be corrected.
Both of those represent the jugular vein of their cases, the heart of their cases.
And that's what you're trying. It's like fishing. You got a hook in the water, you're trying to get the arbitrator out.
Okay. So are there times both the union attorney and the hospital attorney, in our case, chose to make closing statements? When, under what circumstances should they choose to submit post-hearing briefs?
All right, let's begin with this proposition. If you make closing statements, you're going to get your answer in 30 days. If you file post-hearing briefs, usually the parties ask for 30 days or even longer. So that means the decision process is delayed for at least 60 days. That's number one. So the question is, how quick do you want a decision? If it is a complicated fact matter, if it's a complicated contractual matter, if it has some legal implications, then you better file a brief.
Okay.
But if it's a simple fact pattern, such as the one we had today, I think in this case, the party would be well served by making closing statements.
Okay, that's helpful. So from an arbitrator's point of view, in making the decision, what are the most important things an arbitrator is looking for and bases his or her decision on?
All right, take this case. The standard is just cause. What is reasonable under the circumstance? Did the facts happen? First thing. That's what I'm looking for. Now, if the employer proved the facts, then the question is, has the union proved mitigating factors, such as the fact that the grievant apologized? He admitted he had a temper,
Right.
and he'd been employed for 15 years. So what you're looking for is, and what the arbitrators make their decision on, is, okay, the facts are proven. The question is, are there mitigating factors?
So, George, I could go on asking you questions for hours because I love hearing you explain things, but maybe as a final question, in your view, as a very experienced arbitrator, if I was going to start the sentence, the best arbitration advocates always, how would you end it?
The best arbitrator advocates always appraise their cases. They always appraise the possibility of the result. And if they think the result is 50-50 or 40-60, they got to talk about settlement. If they don't, if they think they have a better case, then I think they go through the steps we talked about.
Okay.
Preparing their case, preparing their witnesses, getting the evidence. But if it's a close case, then make your deal and work it out.
Okay, so in the final analysis, risk management or risk assessment is a really important factor.
From the union and employer standpoint. Now, sometimes that cannot be a consideration for many reasons. And in that case, plan the strategy in presenting the case, plan your witnesses, choose your witnesses wisely. You might have 5 witnesses to the case, but pick the 1 or 2 that can do the best explanation of it.
Thank you so much, George. I've really enjoyed talking with you.
Well, same here. It's always great. I'm George T. Rommel Jr., an arbitrator stationed in Michigan, a member of the National Academy of Arbitrators.
My name is Edward Hartfield. I've been a mediator and an arbitrator since 1976, and I'm stationed right here in the Detroit area. This concludes our presentation on the fundamentals of arbitration. And now, I have the great privilege of introducing Dr. Marek Masters, Director of the Master's Program in Labor and Employment Relations at Wayne State University. Dr. Masters?
Thank you, Ed. I appreciate it very much. By presenting you the moving parts of the labor arbitration process, we have emphasized several main points to take away, which include thorough preparation, succinct opening statements, careful questioning and cross-examining of witnesses, focused evidence-based closing statements. If you're curious about what happened in this real case, the arbitrator upheld the grievance and denied the grievance in part. The grievance was upheld in that the terminated employee was reinstated with full seniority. However, it was denied in that reinstatement did not come with back pay. Reinstatement could also be made contingent on the returning employees attending an anger management class. On behalf of Wayne State University and the Doug Fraser Center for Workplace Issues, I'm Merrick Masters, and I would like to thank you for viewing this video. Please feel free to contact us at our website for any additional information about our services.